So as you've just heard there, it's been another week of denials at the Senzo Meyiwa trial. This as all 5 accused have denied knowing Constable Sizwe Zungu or being at the hostel on the day that Senzo Meyiwa was killed. In his damning evidence, Zungu linked the 5 accused to Meyiwa's murder, placing all of them at the hostel in Vosloorus on the day of Meyiwa's shooting. Now, he faced tough questions from the defense on why he failed to act or report his suspicions to seniors if all what he said was true. Now, one of the defense lawyers labels his version as hogwash, while others say his story is a fabrication. Let's unpack the week that was at the Meyiwa trial. We'll be doing this with Marius Toit for now this hour. And let's start with that evidence, Marius, and thank you very much for joining us this afternoon. But that evidence that was given by Constable Zungu, we saw during the week, that was quite damning, wasn't it? Placing all 5 accused at the hostel in Vosloorus. But was it convincing enough? Because there was quite a bit of scrutiny that came out of that.
And I think the scrutiny was absolutely justified. If one looks at the fact that he was a police officer, and here he is in the presence of people that have perpetrated a crime. He says, of course, there was no wrongdoing at the time, but they came back with guns and they seemed very nervous. So at the very least, his suspicions were aroused at that time about their conduct. So one would have expected him to have acted upon that, especially as a police officer, keeping in mind that a police officer has a legal duty to act positively. They have to act because there's a legal duty, and this legal duty enables us to say, well, listen, if I'm a party to proceedings, I should do something about that. And in this instance, he didn't do it. He sat on the information, he kept it. There was a period of time where he didn't disclose it, and then only at the last minute he decided to come forward. So I think the scrutiny is justified. I think at the end of the day, the court would carefully look at his credibility, and these things will definitely count against that. The fact that I failed to make a disclosure when I should have made disclosure definitely reflects poorly on my credibility, and one would only be able to see later on to what extent does this carry weight, because the accused have denied this meeting, they've denied being there. So then you have to ask yourself, on what basis will this evidence really help the state at the end of the day? Or is it just another proverbial nail in the coffin? I'm not sure.
Yeah, and I suppose that's the reason that it's been labelled as hogwash by one of the defence attorneys, saying there actually isn't any actual evidence that will point to all 5 accused being at that particular hostel in Vosloorus. And as you say, it really just puts under the spotlight the argument that is being put forward by the state and whether it will hold water in the coming days.
Yeah, I think one has to remind oneself of the fact that when a court considers evidence, the court must look at the totality of the evidence. The court should not nitpick and shouldn't consider evidence in a piecemeal fashion. And for that reason, you would expect the judge, when he considers this matter, to look at all the evidence and then say, well, listen, if I look at the totality of the evidence, was there a case that the accused had to respond to? Was there a case that they had to come forward and say, well, listen, you now have to give a version to this, because the state has made a prima facie case. So maybe one should be cautious to just outright say, well, listen, I don't know what the value of this is going to be, in light of the fact that he does have some difficulties, and he had some difficulties explaining his conduct. But I think the reality is, at the end of the day, cumulatively with all the other evidence which has been adduced, it might be enough to say, well, listen, this accused has to go into the witness box and testify.
Let's bring in Elton Hart at this stage. Elton, a very good afternoon to you. Let's speak about the defense in this regard and really just the arguments that they would have put forward here. Did they have their work cut out for them, or was it pretty straightforward based on what the state had put forward here?
Then obviously, the manner in which the state actually brought this witness to the fore, for me, that was questionable, the state's behavior. Because, as I said previously, a prosecutor's job is not to every person that steps into the accused box to prove that that person is guilty, but surely to make justice prevails. And if they had this witness in their arsenal from the get-go, they knew that they're going to use this witness, because this witness made a statement around about late 2018, early 2019. So they knew this witness existed. Why not make it available to the defense to say, listen, yeah, we've got this guy that will come and testify 1, 2, 3 against your clients. What is your take on this? Now the defense has to adjust their strategy as the trial, because the state comes up with these surprise witnesses. Now, for me, people were labeling Zungu's evidence as damning evidence against the witnesses, against the accused. But if the accused come and say, but listen, yeah, we never met this guy, this meeting never took place, will their testimony also be seen as damning to say that the witness has lied? And then one asks now, what is it in there for the witness to lie? Yes, there's a lot of motive for him in it to lie, because why does he go 2014 to 2018, give 2019, to come up with such a nice story that places all these witnesses? And when he was questioned about it on the photos that was shown, to say that is not you, that's somebody else, he could not give proper answers. He was just saying, it was me. If you say it wasn't me, then you cannot tell me you were not there. But that was not good enough for me. So this witness, as much as it looks like it's damning, there should be credibility, because he was a police officer. He knew that crimes were committed. He neglected his normal duty as a police officer, not to say to investigate, but to report. Instead of, he condoned what he saw in front of them, sat on the information for another 4 years. Can we really trust the person? Or is this that person that will only give evidence when it suits him? We don't know what he was promised, maybe a rank, something like that. And we need to be optimistic and objective at looking at him. And then his own nephew, he saw his nephew, and he knew that his nephew committed a crime with a 38 special revolver that he has knowledge of. He never reported it. He never did anything about it. So can we trust this witness? That for me is the big issue. And the judge said, yeah, he shouldn't give incriminating evidence against him. But if you look at I want to see how the judge will look at this witness evidence per se on credibility, reliability, and how much weight, as my colleague has already said, the judge will attach to this evidence. Because if there's little to no evidence attached to, or weight attached to this evidence, then the state's case is just another state's case that's going haywire, sideways.
Yeah, and I mean, that's quite worrying, Marius, because one would then look at what Elton has just broken down there in terms of the credibility of this particular witness and think, how does the state then proceed after this damning testimony and the evidence or lack thereof that came out this week?
Yeah, you know, the interesting thing is the defense should never be trialed by ambush. And to sit on evidence, and Elton is 100% correct, to sit on evidence since 2019, and you decide purposefully, I'm not disclosing this, and now at the 11th hour, I try and sneak it in, really stinks. There's no other word to describe it. And the court at the end of the day would have to weigh this evidence with all the other evidence that the state has adduced. But, you know, that will not be seen in isolation. Also, if the accused decide to come and testify, or if the accused decide not to testify, the court will have to take that into consideration. And the court, once he's had all the evidence adduced, he will then be in a position to say, well, wait a minute, this witness evidence was of no value and it didn't take the matter any further. Or no, this person had so many question marks over his evidence, and there are so many things that simply do not add up, that we can't attach the necessary weight to it, so I reject his evidence. So, but that will only know down the line. It's perhaps too early now to say, but I 100% agree with Elton in his assessment.
Yeah, and I mean, with that questionable evidence, Elton, the important part around the nephew and the hiding of that particular gun or weapon, I mean, surely that is bound to come back and bite the constable in the you-know-what when it comes to the credibility of his statements there, only because of the criminal nature of the acts of his nephew here.
No, indeed so. But now what I saw, and this was worrying for me when I saw that, and I don't want to take on the judge and how he actually manages his trial, because he's supposed to manage the trial. But in doing so, he should not enter the arena. And that is clear from that case that he was reading in court out loud to people. He read paragraph 3 of that case for the people, but not paragraph 4, where it says you manage the case, but you should not enter the arena. And when it came to this witness, because he already testified and said he saw these accused. So he opened that door, he dropped that shield for the defense to actually now speak about his choosing and not choosing when to produce evidence. And the judge sort of shut that door for the defense to actually take him on and to say, listen here, but we cannot trust you. And he was supposed to leave that to go so that he can actually see if there is a guy that's willing to go as far as incriminating himself, then it knows, then you can say, This guy wasn't even afraid to incriminate himself to actually make sure the court is placed in the best position with the evidence. The judge shut that door with Section 203 of the, which it gives that a person or a witness that protection. But once you've testified about something, you're supposed to leave the defense, because with cross-examination, the rules is not that tight to allow them to actually cross-examine why he chose to report on the Senzo Meyiwa issues, but not on the nephew's other shooting of Sanaka. And for me, that was worrying what the judge did there. I don't want to speak about the judge manages his case, but also he must manage it both fairly for both parties. And when the state was doing things with these surprise witnesses, and even the second cell phone analyst that is now on the 99th hour called in, witness only given to the defense on Monday, he's not chastising the state for their behavior. But when the defense just sort of steers in the wrong direction, he's quick to say to Mr. Mnisi, Mr. Ramasopili, Mr. Ngumalo, Advocate Mshololo, is quickly to chastise them. Chastising must happen across the board. And that for me was one of the worrying things, sitting as a legal practitioner, watching what is happening. And then you ask yourself, is these 5 accused really going to get justice? And it's said that we'll also now see that this might run down to a situation where people might say, we need to now ask this judge to recuse himself because of entering into the arena when it doesn't suit or need him. And Zungu's evidence, I don't trust that guy. I will not lie. I will not. People can say I'm biased, but I don't trust him. I don't trust his evidence. His evidence to me, even if it's premature, I say it should not have any bearing on this trial.
Yeah, and that's going to be an important point, isn't it, Marius? The weighing of this evidence or bearing of it in the trial, but also the complexities of the Section 203 of the Criminal Procedure Act, and it being in accordance with it incriminating him at all, but also the spat we saw between the defense as well as the judge. So many different nuances that are coming in there, and one wonders if the waters are muddied and there's just no sense of clear direction as to where we are going on an already a brutal or traumatic case for the families involved.
Yeah, let me say this. I think if you go down the road of a judge having to recuse himself, that will mean we'll have a third judge. That will mean we'll start de novo before a third judge. I think that's the last thing the prosecution or the defense wants. And I think they would try and stay clear from that scenario. Having said that, I think it might be too early to say, listen, based on what we've seen, the judge is doing X, Y, and Z, which really causes us to think that we're not having a fair trial, because that's ultimately what one says. If the judge descends in the arena and now suddenly becomes a party to the proceedings, which he shouldn't do, then the effect of it is I'm now saying, as an accused, I'm not getting a fair trial here, because this judge is now playing his cards to such an extent that it's clear that he's favoring the state or he's perhaps against the accused. And how can I now be said to have a fair trial? Now, in a high court, of course, if you feel that my right to a fair trial and there's irregularity in the proceedings, then, of course, you have to make a so-called special entry at that stage. I haven't seen that being made, but the reality of it is, I think it might be, in my perspective, a bit too early to label the judge. I think the judge is trying to be fair. I think the judge is trying to deal with evidence as best he can. And I think in a matter that is publicized as much as this one, it puts a lot of pressure on the judicial officer and on the legal representatives, because every word you speak is being scrutinized. So I just think that at this stage, it might be too early, but who knows? Elton might be 100% correct. Down the line, we might find that cumulatively, if there are so many notches in this trial of the judge doing X, Y, and Z, well, then you then might reach the stage where you say, I have the judge recuse himself. But you'd have to go quite far before you get to a stage where you say, listen, judge, I now think you've become a party to the proceedings. And as an attorney, it's a really sensitive thing to raise. You do raise it. You do it, and you sometimes do it in chambers, and you say to a judge in chambers, judge, this is where we're going. But you only do that as a last resort, because you can imagine if the judge says no, now you've clearly shown your cards. Now you've clearly indicated where your head stands in respect of the judge. And that doesn't bode well for your client, because there's something to be said. At the end of the day, you want to have the atmosphere of the trial in your favor. You want to conduct the trial in such a way that it's to the benefit of your client. You don't want to have your own show. And at the end of the day, you're prejudicing your client. So it's a delicate balance that one has to proceed with.
Yeah, I mean, should we reach that point, Elton, and I know we're talking quite extremes here, but to the point where the judge might be advised in chambers to recuse himself, that would mean for viewers who might not understand fully here that we start from the very beginning, whether it be finding a new judge to preside over these proceedings and then hearing the evidence from the very beginning once again. Isn't that right?
That's one of the possibilities. The other possibility might be if a judge who's presiding over a matter makes proper and clear notes that a next person can actually study the record and look at that person's notes and then take it from there is one of the other options. But that is a dangerous option because normally as a judge, you also observe the demeanor of witnesses when they testify, because that's the demeanor, based on the demeanor that you observe as a judge or a presiding officer, you can then make a credibility finding on that witness. So sometimes you can get where the judges would start in the middle of a trial and just proceed because maybe a judge passed on, he retired, or he was removed from service, whatever the case may be. And the other extreme one would be that we have to start with, if one to say now, Senzo Meyiwa 3.0, that been the third trial where we'll have to start again. And already for us as attorneys, the trial is also tiring on us because to follow, to make sense of the evidence that was given, it's already tiring. Now I can imagine how the witnesses, the defense teams, and even the media would have to now say we have to rewind our tapes and start all over again. So that is not a favorable place to be at. But if needs be, and if your fair trial rights has been sort of half now infringed upon, then you don't have a choice. But already, for me, it's like I say, we need to be careful and already speak up so that the defense teams should actually raise issue with the judge so that the judge can sort of know also that they're not just going to be idle persons. They need to protect the rights of these accused so that we don't get to a point where the situation has deteriorated that far that they have to now ask. Because if you block it up front, we might get a judge that's sort of now managing a trial, playing a referee and interfere where he feels that evidence is not relevant or admissible. Then we're sort of moving in the right direction. But if things get out of hand and now we suddenly want to do this, then as Marius has indicated, then that special entry is not there. So you need to raise that special entry. So for me, if you see that it's going in the direction of infringing, then you need to highlight already to say, listen, yeah, I'm not happy with how, and normally raise it first in chambers. And when it doesn't get better, you raise it again in chambers maybe. You make that entry in court after that. And if it still doesn't help, then you go for the extreme. But I'm just already forewarning and seeing, because already I'm seeing signs. And it was already 2 times where that passage of the judge, the eNCA judgment was read out and thrown at the defense teams. Now, for me, that already, it's red lights. I'm not worried about it, but it's red lights for me.
Yeah. Okay, let's move over to what's coming over in the next week, Marius. We are expecting another cell phone expert to come and testify on account of accused number 2 and 5's cell phone records. Unlike the memory of Constable Zungu, the more technical bits of evidence are something that would come across as more credible unless other bombshells should be dropped in the week. But I highly doubt that if it's as technical as cell phone records. What is your legal opinion on this?
Yeah, the interesting thing about cell phones are that they are similar to fingerprints of old. You know, I don't think people realize that your whole life is contained on your cell phone. Not only does your cell phone contain your movements, but it contains every SMS you sent, every SMS you received, messages you deleted can sometimes be retrieved, and more importantly, your cell phone can pinpoint your location. If they link it up with certain towers, they can say that Marius at this stage is at location X speaking to you, and they base that with certain accuracy. And if they're able to say, well, Marius made a phone call to you whilst at this location and you were at the crime scene, well, that now corresponds with one another and suddenly means that we've got confirmation that Marius might be involved in something. So a cell phone is like a modern day fingerprint. And I think when that evidence is available and that evidence is adduced, it goes a long way to assisting the state in a successful prosecution. I don't think it's used often enough. I don't think in every matter they use it where they have it available. I mean, the reality is, I know that many insurance companies, the first place they go if you lodge a claim is they go and check your Facebook. They want to see what you post on Facebook, because if you were a victim of crime, your chances are you would have posted something. So I think people are ignorant of that fact, and I think this evidence could potentially be very important for the state at the end of the day to say this is what we were able to gauge from these cell phones. And it's exactly as you say, when it comes to cell phones, it's an exact science. We're not talking here about something that maybe you could have done. It's if you had the cell phone in your possession and X, Y, and Z happened on your cell phone, well, you have to explain yourself. So I think it would go a long way in assisting the state in adducing that evidence.
And then just a final thought from you in that regard, Elton, the cell phone evidence that's set to be presented in the coming week, assisting the state, of course, that would bode very well for them given the witnesses that they've had on the stand. But cross-examination could muddy the waters somewhat, depending on the analysis provided by the cell phone expert who's set to testify.
No, indeed. So if one looks at cell phone data in general, and they have a tool or a trick that they use, they call it cell phone triangulation. So they can utilize cell phone triangulation. And I don't know the analyst that's coming, if he made use of this technique to actually see, because then they ping you off 3 towers to see if you were in the center of those 3 towers. Because if you're in the center of 3 towers will pick up your cell phone. Like Marius has indicated, it will pick up and it can pinpoint your location, like not exactly, but more or less. So if the cell phone analyst comes and says, okay, accused number 1 to 5, on this day, 26 October 2014, you were all within a triangle from the Sotho hostel. So then it becomes evidence that is now supporting the narrative that they were at the Sotho hostel on that day, which they dispute. But for somehow, if that cell phone data comes back and it cannot pinpoint exactly the location or in which between the 3 locations the accused person was at that time, then it becomes just information. Damning, not. Because it cannot say with absolute certainty you were in there. But if they have the triangulation and they can say with absolute certainty you were in that triangle, which is in the fossil arrest area. Because what if it comes and he says, okay, I've analyzed the data and I've pinged these cell phone numbers for these various accused, and the one was picked up at that time when the alleged offense happened. He was maybe in the Free State. The other one was maybe in KwaZulu-Natal, as they allege. 2 of them say they were in KwaZulu-Natal, and it says, but we picked them up in KwaZulu-Natal with their cell phones. And one also needs to check, when was these cell phone numbers assigned to them? Because the FICA, you need to look at the FICA information so that we can see, in 2014, did the accused persons use the same numbers that they used in 2020 when they were arrested and their phones taken from them? Because you know with cell phone numbers, it gets recycled. And maybe in 2014, it was somebody else that used that number and not the accused person. So we need to also check in that vein. So only after the analyst is testified, we can maybe unpack it a little bit more to say, how can the state utilize it to its advantage? And how can the defense actually tackle this type of evidence to say it's damning against the accused or it's not really of any relevance to the facts in dispute pertaining to this case.
Very, very interesting insights, gentlemen. Thank you so much for your time this afternoon. That has been our big discussion regarding the Senzo Meyiwa murder trial that is currently underway, with new evidence set to be presented next week. You've just heard there regarding cell phone evidence linking accused number 2 and 5. And of course, what we can expect there when it comes out and what the state and the defense can make with that information. And that, of course, being broken down by legal experts Elton, Hart and Marius, Toit for us this afternoon. Still